Ladies and gentlemen, just in advance of introducing our next speaker, Maurice Cullity made reference to the obligation or the possibility of an obligation on counsel with respect to situations of intestacy in terms of providing more information about it. And it made me think of another aspect of intestacy only because I've got two cases, or I had one and I've got another now in my office, with respect to entitlement on intestacy and the dangers and potential problems when the intestate heirs would be heirs as a consequence of being niece or nephew or cousins. And the cases I'm thinking about or I'm dealing with are situations, in one case against the trustee, another case against the solicitor, typically like this, where somebody comes in, somebody's referred to the solicitor's office, who the solicitor has never met before, but they're referred, and they say, well, I'm here because my neighbor referred me to you, and my Uncle Joe died, and he didn't have a will, and I'm his nephew, and here's a list of the assets. And the solicitor's evidence will be that the solicitor questioned the individual in terms of relationships and everything else. Yes, this is the only nephew, and this person applies for and obtains a certificate of appointment without a will, gets the $1 million estate, and then through happenstance, it is discovered that this person is a nephew by marriage and not a nephew by blood. And of course, now the evidence diverges in terms of the solicitor saying, I discussed it all with him and went through this and explained to him that nephew, for purposes of the Succession Law Reform Act and intestate succession, means blood nephew, not by marriage. And surprise, surprise, the individual says, no, I didn't hear that at all. I always considered myself a nephew, and he called me nephew, and that's what I said to the lawyer. And the same thing, of course, presents itself in relationships like cousin and this type of thing. So with respect to potential liability, both in the context of acting as trustee and also as solicitor, one has to be extremely careful about those intestate situations. And there are searches one can do, but of course the question is, how far can you go if you don't know this family, you don't know this client very well? But importantly, make sure you do a family tree, make sure you confirm to that individual by letter that you've explained the sections of the SLRA and the fact that he's only entitled as a nephew by blood, and he's confirmed that he is the son of the sister of the deceased or what have you, and that if he were a nephew by marriage, he would not be entitled. And at least with that, I think you have adequately protected yourself. Now, moving into a totally different area, Jordan Atin has agreed to take on the topic of estate trustee during litigation, and I'm grateful to him for taking that on, because it's not something that we have discussed in and of itself in the past in programs like this. We've made reference to it in various ways, but we haven't addressed it directly. And Jordan, who practices in Toronto exclusively in the areas of estates, trusts, and mental incapacity, with emphasis on litigation in those areas, has agreed to take it on. He is a regular contributor to publications such as the Estates, Trust, and Pensions Journal, and Money and the Family Law. And I've only had a chance to read part of Jordan's paper, but I think you'll find it useful as he discusses the differences between the obligations and the duties of the estate trustee during litigation and those of the general unrestricted estate trustee. So I'm going to ask Jordan to enlighten us further with respect to estate trustees during litigation.
Thanks, Brian. You're going to find out why nobody else has talked about this topic by the end of this presentation. I have a confession to make. I'm a baseball umpire and a hockey referee, and that's why I have a special affinity for this topic, because to me, the estate trustee during litigation is to estate litigation what a referee is to hockey and what what an umpire is to baseball. The estate trustee during litigation has to be a neutral party above the fray, just like the referee in hockey or the umpire in baseball. He's appointed, the estate trustee is appointed by the court, just like a referee is appointed by the league. And he's not beholden to any of the parties or any of the teams, but has to uphold the rules of the game, or for an estate trustee during litigation, Section 28 of the Estates Act. And furthermore, an estate trustee during litigation is generally an underappreciated participant whose presence is often seen as merely a necessary or just a costly interference in the proceeding, and that is especially like a referee. In this presentation, I hope to cover how you get an estate trustee during litigation appointed, who's proper for the job, and what sort of duties that person is going to have. With the high rate of settlement of state files, it's highly unlikely that you're ever going to have a trial in any particular case. And most times, the only contested matter that's heard by a judge is the motion for directions, and the only contentious matter in that motion may be the appointment of an estate trustee during litigation. And it's often contested because it's important in a couple of ways, psychologically and practically. For the party challenging the will, the removal of the named executor, that's a little bit better, I guess, is important psychologically. It levels the playing field, and it sends a message to the beneficiaries under that will and to the executors that the court will not defer to its contents, to the will's contents. Everything is open for discussion. And from a practical point of view, it also forces the parties to recognize the costs of this litigation, because an estate trustee during litigation is going to be well paid for acting, most likely. And where before the executors may also have been the only beneficiaries and they would have taken the whole estate, now suddenly there's another party there who's going to diminish their entitlement, and that is the estate trustee during litigation, because they're going to be paid. Now, the statutory basis for an estate trustee during litigation, their appointment and their duties, is Section 28 of the Estates Act. And an estate trustee during litigation, am I still here? Yeah, okay. May be appointed where there's, quote, an action touching on the validity of a will, or for obtaining, recalling, or revoking any probate or grant of administration. So clearly, where there's a will challenge on the usual grounds of testamentary capacity, undue influence, lack of due execution, etc., you can get an estate trustee during litigation. And that's the case because the authority of the executor in the will is being challenged as well. This could be the last time anybody delivers this topic because of the because if the will's not valid, neither is the appointment of the executor. So until the court can determine whether a will is valid or not, there's nobody who can deal with the estate. Now, certain circumstances don't engage Section 28 so that you can get an estate trustee during litigation. For example, actions against the estate for contract, breach of contract, torts, quantum meruit claims. You wouldn't get an estate trustee during litigation appointed in those circumstances because it's purely a litigation file. The executor is the personal representative standing in the shoes of the deceased, and there's a plaintiff. There's no challenge to the authority of that personal representative. And similarly, in dependence relief cases, there's no challenge to the will. There's just a question on whether the deceased made adequate provision for the proper support of a dependent. Now, even where a will is being challenged, there's discretion in the court to appoint an estate trustee during litigation. And basically, it comes down to necessity. if there's a need for an interim executor, an interim estate trustee, then an estate trustee during litigation is going to be appointed. Now, there are a couple of important cases on this issue of when an estate trustee during litigation is going to be appointed. And they are Re Lloyd and Re MacArthur, and both of them are in the paper. Now, in Re Lloyd, the estate consisted mainly of private company shares, and the company was being run by the son of the deceased. The court found that everything was being run properly, the value of the company was going up, and there was no necessity for an estate trustee during litigation to be appointed, so it refused to appoint one. And similarly, in Re MacArthur, the court again refused to appoint an estate trustee during litigation. And this case was, I think, a more important case on this question, because there were several wills, and only the last of the wills was being challenged. The same executor was appointed in all of them, and that executor had been managing the estate, notwithstanding the litigation, prior to the motion for directions. And the court analogized the application to appoint an estate trustee during litigation to that of an application to remove trustees, which should be a much more difficult proposition. And the judge distinguished the case. Do I even need a mic, or is everybody hearing me okay? Where the court distinguished the case where nobody had been acting, there's no de facto executor who's been acting, to the case where there's somebody who's in that position who's been acting as de facto executor during this litigation, prior to the appointment, and that's a different circumstance. So and in that case, the court said we don't need one. The people who are managing the estate or have been managing the estate are doing a fine job. I'm not concerned, and we're going to proceed without the appointment of an estate trustee during litigation.
Is this one on now? The other one? All right. He tells me that there's a short in that. And
I've been called worse.
Next time
yes.
you could be zapped. So I would say take that one off.
Why don't you take it off?
I ain't touching that.
It's in my pocket. It's okay. This my coat
Put it
pocket.
over by Archie. Yeah, with the water. Yeah.
Okay. Well, that's going to cut down my wandering a little bit. On the other hand, there's a case called Re-Groner Estate, which is a current case, a recent case. And in that case, counsel had made this arrangement. One of the counsel for the respondent in this case had made an arrangement with their bank. And the bank was going to allow them, the law firm, to invest the estate assets without requiring anybody else the appointment of an estate trustee. Notwithstanding that arrangement, Madam Justice Greer said, look, there's a conflict of interest. You've got one of the parties' counsel acting as de facto executor. And taking into account the size of the estate, I've got to get this organized, an estate trustee during litigation was necessary. And she said, assets can't be administered in a vacuum. Someone or some company must administer them on a daily basis to protect them for the beneficiaries who inherit when the litigation is over. Tax returns must be filed, proper accounts kept, investments made. These are tasks that can only be performed by a knowledgeable administrator. So if you take those three cases, you can get a couple of tips from them if you're trying to get an estate trustee during litigation appointed. One is, show the judge how many duties are going to have to be undertaken during the administration. Show how complex the administration is going to be, and that you can't simply have the de facto, some law firm managing a GIC. Make it look that it's a complicated estate. There are accounts to be kept, tax returns filed, etc. And second of all, bring your motion for directions as soon as you can, because once somebody is in that position of acting as executor, as de facto estate trustee during litigation, then they've got a proven track record. It's going to be harder for you to get rid of them. So you bring that motion for directions seeking the appointment of a estate trustee during litigation as quickly as possible, as soon as you can in the litigation. Now, assuming that the judge is content to appoint an estate trustee during litigation, how does the court pick the right person? Well, the general rule was set out by the Court of Appeal in Re Bezos. And that rule is that a person unconnected to the litigation is the best person to be appointed estate trustee during litigation. Thus, absent very unusual circumstances, neither a beneficiary nor an executor should be appointed estate trustee during litigation. And the rationale is clear. Just like an umpire or a referee, the estate trustee during litigation can't have a stake in the outcome of the litigation. Now, there is that exception that the court left open, very unusual circumstances, where you can appoint a party to the litigation as estate trustee during litigation. And there are two cases here that are helpful if that's what you're trying to do. Get your client, who's a beneficiary or an executor, appointed as the estate trustee during litigation. One is Salisbury and Dell, and the court appointed one of the executors named in the will as the estate trustee during litigation. That person, although they were also a beneficiary, had a very minor interest in the estate, and there were no allegations that that person had acted improperly when they were acting as de facto executor prior to the motion. And finally, and most importantly, they were also the executor named in the previous will, which would stand if the latter will had been was found to be invalid. So they would have been the executor regardless of the outcome of the litigation, and that is an important fact if you're trying to get around that general rule. The second case is a case called Hansen and Hurley, and in that case, it's really the most well-reasoned case on this issue. And there were the same executors named under both wills. However, the executors were the beneficiaries under the prior will, and therefore they were the ones challenging the later will. And they sought the appointment of themselves as the estate trustee during litigation. The beneficiary under the later will said, we need a trust company, a neutral party. In addition to the obvious conflict that the executors were in, the respondents also claimed that they were being treated unfairly by the executors when they were acting prior to the motion for directions. They had attempted to evict the respondent from his home. In fact, interestingly, the respondent had a warrant out for his arrest for the murder of the testator. So that might have been something in the bag. Mr. Justice Rosenberg said, you know, I can sort of understand their hostility. Yeah. Mr. Justice Rosenberg used 4 criteria in determining when you can appoint a party to the litigation as a state trustee during litigation. 1, what did the other beneficiaries think? Did everybody consent? What is there just one person who's opposing this? Second of all, if the executors had been acting, or the party trying to be appointed as state trustee during litigation had been acting previously as de facto executor, then was there any impropriety? Were they managing the estate and administering the estate properly prior to this motion? Third, and I think most importantly, would the applicants remain the executors regardless of the outcome? Because if that's the case, then that question of conflict really isn't there. There's nothing, they don't have a stake in the outcome of the litigation. And finally, how costly is it going to be to appoint somebody else? In Hansen, the judge found that it would have been necessary for the applicants to pass their accounts if they were going to be removed and somebody else put in because they had been acting as the administrator prior to the hearing. And so that the court saw that as an unnecessary cost to the estate. So as I said, to avoid those exceptions from kicking in and to get a neutral party appointed, you got to bring your motion quickly. And that's the best way to avoid somebody getting a good track record before the court. Now, the procedure for getting an estate trustee during litigation, this is really the exciting part of my talk. It's a motion for directions, and it's under Rule 75.06. It's brought with all the other relief sought. And if you think that it's going to be an issue as to whether, as to the identity of an estate trustee during litigation, then you've got to address a few major points in your affidavit supporting the motion. Normally, people, at least in my experience, what I do on a motion for directions, if it's a simple one, is really do a very simple affidavit. But if there's going to be an issue, then you've got to address a few factors in that affidavit. 1, is there an obvious conflict? Is the person who's seeking the appointment a beneficiary or an executor? Is there some sort of conflict there? 2, And these sort of follow Mr. Justice Rosenberg's comments, but has the executor acted improperly in any way during their de facto reign as executor? And thirdly, is there going to be discretion necessary to be exercised during the administration? For example, is there going to be a dependence relief claim that may have to be settled? Okay? And that's going to require discretion by a neutral party. So that's a helpful a check mark there to make sure that you've covered that off. If there's going to be discretion, you don't want a party to the litigation involved. Now, there's a sample appointment of an estate trustee during litigation in my paper, and you can have a look at that. As far as the authority of an estate trustee during litigation goes, basically, they can do everything that an estate trustee without a will can do, except distribute to the beneficiaries. So they've got very, very broad powers, and I'm not sure that you have to put much more into your order than that. But people commonly do, and that's fine, but you resort to Section 28, which says that they have all the duties of a general administrator. One clause that I would recommend, and I think Brian mentioned this earlier this morning, is a clause dealing with this compelling disclosure of records from hospitals, banks, solicitors, and I would recommend putting something in there. If you want the estate trustee to be the person to obtain those records, then I recommend strongly that you put something in there giving the estate trustee, or making it explicit that the estate trustee has the power to compel the production of those records, because that will give the hospitals and the banks and the solicitors more comfort in turning over the documents. Now, just getting back to the motion for a second, oftentimes it's clear that a neutral party has to be appointed. And it's clear to everybody but one lawyer or one side, and they insist that their client be appointed as the estate trustee during litigation. And you have to go and attend on the motion because that's going to be argued. There is case law to support cost sanctions in such a circumstance, and that's Reese Silverstein Estate. And in that case, Madam Justice Greer said that it was clear from the outset that we needed a neutral party, and imposed cost sanctions against the party who objected to that. And so that is helpful if you ever have to argue that issue. Now that we've got the estate trustee during litigation appointed, we're going to look at what one does as an estate trustee during litigation. They have very broad powers, as I've said, and at least I can characterize them in four main areas. One, dealing with assets. Two, gathering information for the parties. Three, paying debts. And four, assisting the parties in resolving the litigation. Now, with respect to assets, an estate trustee during litigation has authority to value, hold, lease, manage, and sell estate assets. Of all of those possibilities, the estate trustee during litigation has to be most mindful of selling assets. Of course, until the litigation is concluded, we don't know who the proper or what the proper disposition of the assets is going to be. And therefore, if you're in a circumstance where the will provides for in specie disposition of property, as an estate trustee during litigation, or if you're advising them, you can't sell that property without the consent of the beneficiaries or a court order. And Section 28 places the estate trustee during litigation under the immediate control and direction of the court. Therefore, if there's a decision that substantially affects the rights of a beneficiary, the estate trustee during litigation can go to court and get their opinion and direction and approval. That brings me to the one big difference between an estate trustee during litigation and an umpire. Because as an umpire, I can't ask anybody else for help. I've got to make the call, and if it's a hard call, I've got to live with it and live with the manager coming out to argue with me. And I'm sure that everyone has seen one of those arguments where the manager runs out and starts going nose to nose with the umpire, and usually the umpire is quiet and the manager is the one screaming. But occasionally, an umpire just can't resist a one-liner. And the best one I've heard of is there was a hard-hit line drive right down the right field line, and it was hit so hard that the umpire didn't have time to run out and get a close look at it. He had to make the call from like 300 feet away. But sure enough, he saw it bounce right on the line, and he signaled fair, which is the right call, at least in his mind. And the manager came running out of the dugout and argued, you know, that ball, it must have, how could you possibly have seen it? You were 300 feet away. Are your eyes really that good? And the umpire said, look, on a clear day, I can see the sun, and that sucker's 93 million miles away. The second duty is information gathering. And typically, the parties will use the estate trustee during litigation as sort of the clearinghouse for information. They're given the job of writing to the deceased bank and financial institutions, hospitals, solicitors, getting the documents that are required. And that's why I had suggested that you include a clause in the order giving them that authority. Thirdly, they have to deal with debts and liabilities. And this can be the easiest or the toughest part of their job, because some debts are very easy to calculate and pay. You got credit card debts, funeral expenses, taxes are even pretty easy to pay. So those are the easy ones. But occasionally, the estate trustee during litigation is in a position where there are claims made against the deceased by third parties, or more importantly, more difficultly, is a dependence relief claim, for example, by one of the parties. And of course, to have a successful dependence relief claim, you have to prove that the deceased did not make adequate provision for the support of the dependent. And you can't know that until you find out which will is valid. So you won't know until after the litigation whether you can prove a dependence relief claim. But oftentimes there's an interim relief sought in a dependence relief claim. And in my view, what you have to do is you'd certainly be in jeopardy if you try to settle the whole dependence relief claim. And settling even the interim part is difficult. I think what your best advice is to go to court and let the court decide on that. As far as settling other debts, there's a case called Re Razankowski, which is a decision of Madam Justice Kitely, very recent. And its authority for, I don't know if it's authority for, but the estate trustee during litigation brought a motion to approve a settlement with the PGT. And there was opposition to that motion. But most importantly, the court did not criticize the estate trustee for going to court and getting its approval on when it had to compromise a claim. And that's important to know if you're acting for an estate trustee during litigation. Now, my final point is one function of the estate trustee during litigation that's often overlooked, and that is participating in the settlement of the litigation. We're seeing it more and more now that mediation is upon us. Many counsel are requiring the estate trustee during litigation or its counsel to be present at settlement meetings and at mediation. Well, why is that? Well, when you settle an estate case, most important is the bottom line. What's left at the end of the day to distribute to the beneficiaries? That's how you're going to get a settlement. And the estate trustee during litigation knows, or should know, exactly where those assets stand in the estate, what's going to be left at the end of the day, what's in that GIC, how much commission is going to be payable on the house, is there an interest in Aunt Mabel's estate that's going to be coming down the pipe? So all of these questions can be answered right at the mediation, and you know it. You can make a deal that's going to be binding, and nobody's going to say, oh yeah, we forgot about that asset or this asset when we settled this. So it's important, I think, to have them at the mediation. It's also important to have them at the mediation because then they know what the terms of the settlement is, or are. The terms of the settlement are. Because they may be the party that's going to be administering the estate after the litigation. And it's important that if they're going to do it quickly, that they know exactly where the parties are, where the parties have settled, and why they've settled it in that way, because it's going to assist them in transferring the assets as necessary. Now, finally, some counsel even have the estate trustee during litigation at the discoveries. I personally had never thought of that, but the theory is that if the estate trustee during litigation is there, or their counsel is there, then when it comes time to settle it, there's somebody who can be an unbiased objector and say to you, you're wrong, or you're right, or that's not the way I saw the case. And it's almost like a pretrial as well. You've got somebody, especially if it's an experienced counsel for the estate trustee during litigation, who can assist in evaluating the case. So as you can see, the appointment of an estate trustee during litigation is an important step in any litigation. It levels the playing field, and it brings into the litigation a neutral party. And finally, that neutral party is somebody who can not only be a custodian of assets, but also the facilitator of a settlement. Thanks very much.
Thank you, Jordan. I would just make one appeal with respect to estate trustees during litigation. As Jordan says, there's many situations where certainly it's not only appropriate, it's necessary. But there are a number of situations also where it's not necessary, and where counsel, being a little innovative, can come up with a means of managing, especially a rather simple estate and modest estate, without getting an estate trustee during litigation in. Usually when you have one appointed, it's a trust company. In many circumstances, you need one. You pay for it, that's the best way to go. But I've seen many situations where it's knee-jerk. We've got a challenge to a will, therefore we need an estate trustee during litigation. And it's not necessarily so. So look at the situation carefully before you and opposing counsel make the decision that you're going to seek the appointment of an estate trustee during litigation. Now, we come to our last lecture, and I tell you from experience, it takes a tough and very self-confident individual to deliver the last lecture of the day in a program like this, which is why I delivered the first lecture of the day in a program like this. And Archie Rabinowitz fits the bill perfectly. Archie is co-author of a publication of Carswell's The Practical Guide to Ontario Estate Administration. He's a partner at Goodman & Carr in Toronto and specializes in the field of estate litigation, and I know is well up on not only the new mandatory rule, or the new rules of mandatory mediation, which he'll be speaking about, but we've also asked Archie to address the question of the skills and the approach necessary for counsel as an advocate on behalf of his or her client in a mediation. Because, as I'm sure any of you who have been in a mediation will accept, it's a very different role than when you are counsel before the court for the individual. And we must learn the differences of that role and the skills that are required of us if these mediations are going to work and are going to very much shorten the process and hopefully reduce the cost of the process. So to speak to us on both our 3-month-old mandatory mediation rules and the issue of how we can effectively advocate on behalf of our clients at mediations, I introduce Archie Rabinowitz.
Thank you, Brian. I appeal to all of you to ignore what Brian has said about me. He's just trying to get on my good side for a settlement meeting that we have scheduled next week, and it's not going to work. But in any event, I agreed to speak to you today, the last speaker in a 2-day conference on condition, and I explained to Brian that he'd give me a short topic where I wouldn't have to make any reference to case law, so I'm obliged to Jordy for having exhaustively reviewed so many cases to take me off the hook. The new rules of mandatory mediation, as Brian has explained, are only about 3 months old. They came in September 1st. I have reproduced the rule and summarized it in my paper. The rule is reproduced at the back of the paper. And I don't want to spend a lot of time regurgitating what the rule has to say, other than just to briefly outline some general pointers about it and then get to whatever comments that I can make about advocacy at mediation. And as Brian quite correctly points out, the advocacy at a mediation is far, far different. You should know that just because the rules are mandatory now, a number of us have been conducting mediations of contested estate matters for some time, but this is now the first time, I guess, that it takes it out of the completely voluntary world to the mandatory world, and it's just going to take some time for the profession to become more comfortable with it. Now, the fact that it is mandatory as opposed to voluntary has always scared me a bit, in that I found that those cases where the parties just did not want to go to voluntary mediation for whatever reason, either because they hated the guts of the other side or because they viewed it as a sign of weakness, I always lacked, I guess, the leverage to encourage those people to do it. But it's strange how sending out the very reasonable legal bills that we all generate has the effect on clients of getting them to not be quite as hardened in their positions as they were initially. The fact that it is mandatory isn't something that I'm any longer concerned with, because the first experience that we had with this, for those of you that practice in general litigation, we of course had some experiments in mandatory mediation in some of the other areas, and the ratio of success has been tremendous on that side. So I wouldn't really worry about the fact. And this is a good now opportunity. If the clients give you a hard time in saying, I don't want to go to mediation, I don't want to show any signs of weaknesses or anything like that, you've now got the perfect excuse in saying you don't have a choice, and if you don't, there are going to be terrible consequences to you, and the consequences are provided for in the rules. I think it's been left up to judges to craft their own consequences, but I guess in the extreme, I've never heard of a case of this happening, but I suppose in the extreme, parties pleading or something could be set aside, but I suspect it would rarely occur. Now, the only two regions where the mandatory mediation are in place are Toronto and Ottawa. I have noticed over the last 3 months this has curiously resulted in a little bit of attempts to do some jurisdiction shopping, where counsel have attempted to find a way to get matters that otherwise should have been in other jurisdictions put into those jurisdictions. And again, I don't think the judges in Toronto and Ottawa are going to be all that receptive to it, and I've heard some comments where the opening remarks have been by the judges in saying, how does this possibly fall under the Toronto Estates list? But I just mention that to you, that if there is a way that you can justify it, normally if it's a will contestation, my understanding is the jurisdiction has to be where the deceased resided, but there might be other situations under the scope of Rule 75.1 that might give you some room for creativity. The essence of how you get the mediation rolling under the mandatory rules is a motion for directions, and Jordy talked to you about a motion for directions leading to the appointment of an estate trustee during litigation. Similarly, there is a motion for directions with respect to all aspects of the mediation. And again, I summarize what areas are covered and how the courts deal with it in the paper, and I don't propose to do that. But I just mentioned to you that there are already notices going out on cases for mandatory mediation, and there will soon be, I suppose, and I look forward to seeing it. I'm not sure if it was in the last release in Brian's textbook on estate litigation, but I'm sure there will be a draft precedent for the language and paragraphs that should go into a standard order for directions with respect to mediation. Now, the costs of the mediation are something that I would encourage everybody to address at an early stage. If the parties don't come to an agreement on this, the court, of course, will deal with this at the motion for directions for mandatory mediation. The reason I would encourage counsel to address this at an earlier stage is because often in estate litigation, you're not dealing with the classic plaintiff versus defendant aspect. There are often other beneficiaries who may or may not be taking a position in the litigation but have an interest in the outcome. In other words, their interest may be impacted positively or negatively as a result of whatever proceeding is before the courts. The typical way that I've seen the matters dealt with is if it can be identified that there are two opposing parties, if they could come to some agreement to split the costs of that in some way, whether it be evenly or something else, that's going to, I think, avoid arguments. And if it is something that the judge forgets to deal with in the order giving directions, believe me, when you get the bill, you'll obviously find out that it's an issue that has to be dealt with very quickly. So again, I just want to point out that our experience on the civil mandatory mediation side was that often the orders really didn't deal with the issue of costs, and people would get into fights over payment of invoices and things like that. So try to deal with that early on. The other thing is choosing your mediator. The rule refers to a list of mediators or a panel, and many people in the profession think they're limited to those people on the list. You're not. If the parties consent to anybody, virtually anybody, you can pick someone off the list. The problem is that if you're going to pick someone off the list, do make sure that you've consulted with McTavish, Lalonde and Associates and the Public Guardian Trustee's Office to make sure that everybody's on side. And I think one of the biggest learning curves there will be in estate litigation is the fact that we've got, again, not the traditional plaintiff versus defendant, but a whole array of other parties, including government agencies, that really have to be included in the process. Obviously, if the parties don't agree on who the mediator should be, the judge, actually there's a form that gets filed with the court and one gets selected for you, and you also have less input, I think, on the date if one gets selected for you. So again, from practical reasons, do try to negotiate this out in advance. Now, the part of the advocacy at mediation, before you even get there, if you don't take advantage of the written statement or the written submissions or memorandum that you're going to file, I think you've probably lost one of your best opportunities in the advocacy. The advocacy at this sort of hearing, at a mediation session, I should really call it, not a hearing, it doesn't allow for trial counsel to really show off their stuff. That's not what goes on at these mediations typically. The mediator isn't the one that has to be persuaded. We all get paid, for those of us that are crazy enough to don the gown and step into the courtrooms. We get paid to persuade triers of fact, and that's not what we get paid to do in a mediation. In a mediation, I view our role as simply being there to put forth the positions for the parties, but really that's done at an initial stage, and even on that initial stage, I always encourage the clients to speak as much as possible. Often the clients are coming in these hotly contested and emotional issues, for example, on a will contestation, with all sorts of emotional baggage that really the rules of evidence are not going to allow this kind of evidence to come out. And even though the clients tell you that the real reason they're fighting their brother or their sister or whatever it is about has to do because when they were kids, Mom let my sister take the caddy out for a Saturday night and I didn't. And I know it sounds petty and silly, but many of us have been involved in situations where we can't believe that it boils down to these kinds of nonsensical things. And I tell clients that, look, if you don't talk about these kinds of emotional things, and if you don't mention these at the mediation, you're never going to get a chance to do it, because you're not likely to be in the same room with your opponents, with counsel, and you're certainly never going to get away with saying it at a trial. And so again, I encourage the clients to do more talking than the lawyers. Now, some lawyers feel they have to, either because your client is too nervous, too emotional. But if that's the case, then I would encourage the lawyers not to push the emotional buttons at the mediation, but simply highlight the facts, highlight the legal propositions, not in any detail or length. And the real fun starts when the lawyers shut up and the mediator goes out in these caucus sessions. And I don't know how many of you have had any experience in conducting these mediations, but they're a panic. That what essentially happens is it's irrelevant what the lawyers say in their opening speeches. The fun stuff starts when the mediator takes you out and either asks to speak to counsel alone or to one side, that is counsel and clients. And usually the more experienced mediators will tell you, I think you're completely full of hot air. There's no way this thing is ever going to settle at X dollars. What do you think? And why don't we try an offer on for size at this? Now, sometimes, obviously, we're talking about disputes that that do not reduce themselves down to monetary settlements alone. But again, by analogy, what I say is the fun really starts when you go out into these caucus sessions and these private negotiation sessions. And I think your duty and our duty is to, without selling our clients' positions down the river, encourage them that this is a better alternative to the litigation abyss. Obviously not better for our billings, but really far better in the long run for the clients. And if history proves itself in the way it has so far, by the time Brian and I get finished with an estate, or Ian and I, or anybody else out there, if we go all the way, there's very little left in not all cases, but many of those cases, and that's just not right. So I view our role as really trying to encourage the clients, speak up, say whatever they want. And by the way, if the clients are reluctant to say something in front of their relatives or in front of the other side because of some fear of something, they can even be encouraged to say it in private and in confidence to the mediator in one of these breakout caucus sessions. And the mediator will explain at the opening of any mediation that they're obliged under rules of confidentiality to, if they're instructed to keep things confidential, they will. And there's no doubt that the mediators that have been assigned and that the ones you will pick are going to honor that. Now, Rodney Hull taught me many years ago, and I'm sorry that I missed his speech. I understand it was quite colorful, that if you come up with a settlement, a negotiated settlement with the parties, and you're concerned that a judge is never going to sign the order, forgive me that I quote him, I don't know if he's here, Ian, screw them. The beauty of mediation is that you can really craft a settlement, and depending, of course, on whether or not the public guardian trustee and Office of the Children's Lawyer is involved, you can often come up with solutions on how to deal with contested matters that there's no way that a judge would ever rule in that fashion, because let's say if it's a principled approach and it's an all or nothing, at a mediation, you're able to literally carve the baby in half. The other beauty is that you don't necessarily have to get court approval. Again, I say not necessarily. There are circumstances where you're obliged to do it, and I don't want to instill panic in the face of Anne Lalonde, who's sitting here to say that we should be doing deals behind their backs. But if they're not involved and they're not participating in it, there is an ability at a mediation to craft solutions that don't necessarily need court approval if there's concern over that. And indeed, Jordy mentioned the Silverstein estate file. That was one where that exact thing precisely happened. I was counsel at trial before Mr. Justice Sheard at trial. That's precisely what happened. there was some discussion by Jordy as to whether or not the estate trustee during litigation should be present at a mediation. And I just sort of briefly want to talk to you about making sure that before you go to mediation, make sure that everybody is either there or represented, because you can run into difficulties in coming to settlements, whether at mediation or otherwise, but certainly at mediation, if not all the parties are there and you make assumptions about what parties are going to do and what they're going to approve of, etc. And two reasons that I can think of as to why I would want to insist that the estate trustee during litigation is present at a mediation are as follows. Often, the parties are dependent upon the estate trustee during litigation to give them updates on the status of the assets of the estate and under their control. And often, if, let's say, there's a trust company involved, we're only relying on some quarterly statements that may be outdated, or if there are U.S. Investments, there could be, or stock investments, there could be some serious fluctuations in value. And the advantage of having the estate trustee during litigation there is you're more likely to have more up-to-date and accurate information on the value of the assets. And often that's what the mediation is dealing with in terms of dividing up the pie. So you want to make sure you've got the best information up at the mediation. The second reason is, in many cases at these mediations, if there's an estate trustee during litigation, we're often talking about getting rid of the estate trustee during litigation, and not exclusively, but most often when they're a corporate estate trustee during litigation. I don't know about you, but my experience is they tend to want to get paid for some reason, and we have to negotiate something on account of their compensation. And when we haven't got them there to sign off on X thousand dollars in terms of compensation and whether steps have to be taken for the filing of trust returns and things like that, that's another thing that can fall through the cracks. So often parties will think, well, we just have to be here. We're the only parties that are fighting. They go, they make their own provisional deal, and then realize when they circulate a confirming letter happily advising the estate trustee during litigation that the parties have come to a settlement, where the estate trustee during litigation says, excuse me, you forgot one little minor detail. Now, I have listed in the paper a number of advantages to mediation in contested estate matters, and only a few disadvantages, and I don't think it would be a wise use of time at this late hour to go through those, but I just want to conclude by telling you that this is something that members of the Rules Committee have been working on for a long time and have put a lot of effort into, led by Malcolm Archibald, and this is something that I think many of us who practiced in the estate litigation world are very excited about, because the prohibitive costs of running the typical matter up the flagpole in traditional litigation has just it's just made it so prohibitively expensive for litigants to fight it out. They can effectively fight it out at a mediation because of this openness and this absence of any restricted rules of evidence. So if subject to any questions you have, that's all I have to say, and thank you for listening.
Archie made the comment that with mediation, litigation counsel doesn't have the opportunity to strut his or her stuff the same way that you do in court, which is true. I do point out that, especially in our area of litigation, at the end of a successful mediation, what you want is a written settlement. You do not want at the end of a mediation, and these typically, I've not had one that's ended in half a day. I find it a waste of effort to even book it for half a day. It takes a while to get a sense of what's happening. They take a day, and very often into the evening. I've had some that have gone 3 days. But the point is, at the end of it, You want a written settlement that everybody signs right then and there. So this means that while you don't have the opportunity to strut your stuff in terms of litigation counsel in court and arguing the case, you have to strut your stuff in terms of being able to sit down and write out the minutes of settlement. And when you're accustomed, as most of us are, to having the quiet of our office and dictating or working on our computers and getting out all the precedents and doing this, but instead, typically in the mediation, one of counsel is writing it out in longhand and then giving page by page to somebody else, other counsel who are reviewing it, making changes, and then you finish with some garbled mess that you hope never will have to be interpreted by a court or enforced by some party in a court. But it is a good idea, I'm just doing this now, to start putting together, sort of a mediation precedent book so that when you sit down, and also, I should say, to have an idea that if you're going to settle this, what sort of things are you going to want in there? Who are you going to want released? How, what kind of release, and bring along some precedents to help you when you're sitting there and drafting, because it's not an atmosphere where you can say, or you want to say, oh, just a minute, let's sort of break tonight and we'll go back to the office and we'll draft it. You know what's going to happen. They're going to have a chance to think about it and you're back to square one. So your skills are different, and those of us in litigation who aren't quite as accustomed to getting involved with the drafting, yeah, we draft minutes of settlement, but we do it, again, in the calm, cool atmosphere of one's office and without being hurried and without having to write it out ourselves. It is a very different experience. So that requires another set of skills that perhaps in some of us have become a little rusty over the years, but have to become well-oiled. I'm going to close off the program by just expressing three thoughts. One is that on your behalf, and I know most of the speakers aren't here, but some of them are, but it doesn't matter. I at least want to, on your behalf, thank all of the speakers today for the effort that they put into not just the oral presentations to you, but the papers, most of which I've had a chance to at least review quickly, and they are extremely valuable papers. So I thank them on your behalf. Archie and Jordan and I will remain for a few minutes if there are further questions. I have a few questions that I haven't had a chance to talk to people about. I will call you next week and discuss those with you and offer the benefit or otherwise of comments on them. And finally, our thanks to you for your consideration, for your attention today. And the hope is that some of what you've heard today and what you're taking with you will be of some degree of help in your practices. So thank you very much.